Leanne, thank you for putting this together today. Would you introduce yourself and your guest?
Certainly. Thanks, Dan, for having us today. My name is Leigh Yates, and I am a practicing risk manager. I've been in the field for over 25 years. With, experience level, I've consulted nationwide and practiced at, large acute care facilities, physician practices, and, just ambulatory care, access hospitals. So I'm excited today to introduce to you Scott Shinkan. Scott comes to us from Clausen Miller. He is a trial and appellate lawyer who represents hospitals, physicians, and state patient compensation funds in professional liability lawsuits nationwide. Scott has a wide variety of experience and has been in the field for some time now.
What do you expect our audience will get from this conversation today?
I hope that today will be a good dialogue and for risk managers to really think about the litigation piece of the work that they do. Oftentimes risk managers come to us and maybe they don't have the experience or all the spokes of the wheel. And what I mean from the spokes of the wheel, you have the insurance, you have the litigation, you have patient safety, you have the nursing aspect, the quality regulatory. Not every risk manager is educated on the litigation side. And so hospitals might have a third-party administrator that helps them with the litigation, or they may have their risk manager, provide that function to the institution. So today, I'm hoping that the risk managers will glean knowledge and information from Scott in our conversation to be able to take back to their institution and really ask the why behind all of it, because they really need to understand the processes involved, the risk exposure involved with the lawsuits that are coming up, because you keep driving it back and it all boils down to standard of care, whether standard of care has been met, and the financial aspect of when the standard of care has not been met. And so risk managers are charged to be able to project loss. And when we look at our enterprise risk management program versus our traditional risk management program, we need to make sure both of those complement one another and address all the risk that is present in our daily operation as a healthcare institution.
All right, awesome. Let's get started.
And thank you for that, Leanne. I look forward to having this conversation. I think there's a lot that I can offer, and I look forward to going through all of this. Before we go, of course, let me first say that all the views that I'm going to be expressing today are my own. These are based on my personal experiences. My comments are my personal comments and do not reflect the views or positions of Clausen Miller or any of our clients. Good, so we got that down, so let's talk.
Let's talk. Okay, so, the thing is what we're trying to do here is do more knowledge sharing, because I think that in our field of practice, there's probably, people don't have enough time and to be able to knowledge share appropriately and to shore up those gaps in knowledge or education, I think is important to be a really good risk manager. And I say that in preface to, as I have walked through my journey as a risk manager, some of the most important colleagues of mine have been the legal team. So in any position that I've held, I've always tried to surround myself with good folks. And so that way you can collaborate and share information. And so what I would like to talk today with you, Scott, about is, risk managers, one of our duties is to plan ahead. And when we think of enterprise risk management and planning for epidemics and pandemics, those things should be on the forefront of what we're thinking about is the unthinkable and planning in accordance with that. So unfortunately, I think over the last year and a half or so, as COVID has entered the working world of what we do today, it's really kind of handicapped some folks that really weren't so prepared. So when you think about all the things that are happening with COVID, and now I think we've come to like the bend in the curve, and our whole workflow has kind of changed and how we think about things And as you see it on your side, you're starting to get COVID claims and, preparing people for a deposition and all. And when you think about that, I wanted to see, nationwide, are you seeing any sort of trend or pattern with other healthcare institutions, or they don't even really have to be healthcare, but are you seeing those trends as far as litigation strategies or investigation techniques that you're putting into practice at, Clausen Miller?
Well, I think it's still young. Medical malpractice claims always seem to lag behind, everything else, and that's because the plaintiffs typically have 2 to 3 years or more based on, we have discovery rules too. Sometimes it can take a while for those claims to get to us. So as far as the national trends go, there doesn't seem to be any specific trends in working up these cases that are particular to COVID. I would say that the workup has been pretty similar to how we work up cases in the past. And there's nothing, regarding COVID in and of itself that sort of changes the way that we do it. Now, of course, there are unique circumstances of a COVID case. There are some of the, there are some issues that are clearly unique to COVID. It's an aggravating factor. It's a hot button for some. But, we see that these are a lot of the same issues that come up in COVID cases versus other cases. There's, the issues of misdiagnosis, failure to treat, informed consent, delays in surgery. There's arguments of abuse and neglect in understaffed nursing homes. There's failure to follow protocols, failure to use certain apparatuses like adjusting the ventilator. Those are all types of claims that we saw even before COVID. But now, there's a few other issues that are a little unique to it. There's the statutory immunity concerns. There's some executive orders. There's the constantly shifting CDC guidelines and other guidelines. So, you have to be mindful of those when you're working up the cases. But at the end of the day, we sort of follow the same methodology of working these up as we have, other types of cases, cancer cases, orthopedic cases, you name it.
So that leads me to my next thought is, as you are, working the case up, for instance, if you got an incident that was assigned to you, or the risk manager hired you to help with, a claim, maybe a pre-litigation claim or a lawsuit, what can you tell risk managers that they would, be better prepared to produce to you? What is the list of things that you absolutely need to be able to prepare a good defense, for your client?
The documentation is the key, and we're going to keep coming back to that today on our conversation. I can't impress upon everyone enough how important the documentation is by the time that it gets to us. By the time that the cases get to me, I like to see that we've got a copy of the records, that those have been preserved from all departments. Sometimes things get lost in routine recycling. Sometimes notes get recycled, but any notes that we can get, any medical records that we can get from everywhere, we need that. We need to get copies of the policies and procedures. We need to get, any notes that were part of the peer review process, and know that that process and that the reporting to, patient safety organizations has been followed. If we would want to make sure that that there has been considerations of, whatever your state's Medical Studies Act or your Peer Review Act calls for, to make sure that these documents are privileged, that, you need to be aware of those and need to make sure that you're following that, before you start interviewing witnesses and preserving the evidence. if it's if we're talking about surgery cases or the instrumentality, it would be very helpful to have, preserve that, to allow us a chance to photograph the evidence if there's evidence involved. Documentation is the key to everything that we need.
Well, and I'm glad that you brought that up, because documentation is always a problem for risk managers usually, because I think, fear drives a lot of the documentation issues. For instance, if there was like a bad outcome and maybe a patient died or something like that, you might find that some of the folks involved in that situation might have kept private notes, maybe at home, or separate and apart from the normal documentation system. And so I think that's important as risk managers when you're trying to figure out, if you want to interview a key witness, to make sure you ask, do you have any notes at home? Do you have any private notes outside of what you documented in the appropriate software? Because we certainly, as risk managers, our job is huge to try to educate when we can and keep things in alignment. And as if certain things happen, there might not be protected work product if you didn't, produce in a certain way or document in a certain way. So we want to make sure that we keep a narrow path to protect the institution and reduce risk exposure. But I think documentation always, because if the story's not told, somebody's going to make up that story and fill in the gaps. And unfortunately, sometimes with the information that we give lawyers like yourself, there's gaps in the documentation. And, talk to us a little bit about how you shore that up, because in the end, if there are gaps, you're left to tell the story and to create that reasonableness with the care that was provided by the client, the insured, the hospital system, whoever it might be.
Yeah, I mean, I certainly agree with all of that. First off, you need to make sure that the witnesses, not only did they not record something at home, but sometimes they might have wrote up a note to their supervisor and thought nothing of it and assumed that you had received that. So you really need to find out, is there any documentation that you made anywhere? And even asking, where did you make it in the chart? Because sometimes, especially with electronic medical records, you never know where in the chart their note might have ended up. It's for the plaintiff's attorneys, it's all about exploiting holes and creating confusion to make it look like something, either never happened, that is not contained in the chart, that the witness is saying did happen, or the opposite to it. So, with plaintiffs just trying to take the record to exploit, what they can in the documentation, it's imperative that everyone in the building is documenting as much as they can, within reason. And that starts with triage, nursing, the doctors, and then once the peer review process begins, again, documenting that whole process and making sure that those are readily accessible to the lawyers. Again, you need to make sure that you're following whatever procedure is required by your peer review act or the Medical Studies Act, because that's where the plaintiffs are going to begin to try to turn this into what a lot of people call courtroom medicine. Plaintiffs love to take the focus away from, how real medicine is practiced. That they love to take it away from, what really happens out there with doctors making quick decisions in real time, based on objective evidence constantly coming in and changing and applying their education and background and training. So the plaintiff's attorneys then like to kind of create this courtroom medicine in which, you've got a list of rules, you've got guidelines, there's textbook articles, and then, doctors are expected to know every word from all of that and are expected to follow those. So they try to employ that strategy and relying on the documentation to show what actually happened, and to support the anticipated testimony, that's what we need from the defense lawyer's perspective.
And part of the risk manager's job and role is to figure out where the weak link is. And sometimes it's the credentialing process in which, the peer review documents and how those are kept and recorded and all of those sorts of daily operational things. Now, or it might be, we don't have the right process and protocol in place, or we don't have a policy. And, that's the first thing that plaintiff attorneys ask for is, let me see your policy and procedure. They want to see where you deviated from it so they can create even more liability for you. But we all know, like, once we realize if we have a case that, or an incident or an event that is problematic and we think it's headed towards litigation, or maybe it is in litigation, we want to quickly resolve it and cap our exposure because, at the end of the day, it's dollars going out the door. And it makes no sense to work a case up for 2 years when we could get it resolved, when we know there's liability and problems. If we could get it resolved today for X versus 2 years from now and pay more, it's illogical to keep it going. So part of our role also is to be aggressive in evaluation. I know some plaintiff attorneys use a certain algorithm where they will not talk to you about resolution until they take the depositions of staff or work the case up a little bit. Do you guys on the defense side have that same sort of algorithm or, recommendation? I mean, are you in favor for the early resolution and being aggressive on the front end? What's your take on that?
Oh, certainly. I mean, it's not a one size fits all, but, I think it's always good to consider early resolution. And there are a lot of considerations to it. I mean, I don't have a specific algorithm, but there certainly is a methodology to it. Early on, you want to try to obtain as much information as you can, sort of follow the insurance company's guidelines and their comprehensive report to see everything that the insurance company needs to evaluate the case and make decisions on how to proceed. That there are some cases where it is appropriate and, some cases where it might not be. Unfortunately, different plaintiffs' attorneys have different styles, and some feel like they need to show their clients that they're fighting for them. And so, like you said, they do want to tee up a bunch of depositions first. And some plaintiffs too, they want to feel like they've had their, quote unquote day in court. And sometimes, plaintiffs think that requires some depositions, but, if you can get on an early resolution, maybe tee the case up for an early mediation, that can sort of act like their day in court, give them a chance to talk with the mediator, to get it off their chest and to get some resolution. You mentioned, plaintiffs do have their scripts, their working grids, and I don't find it particularly helpful. I think we've discussed this before, that every case has some sort of value. No matter what the facts are, there is some value to the case, and that value changes at different points in time. And one of the keys is that you never know what problems that the plaintiff has, and so the trick is, to get the plaintiff to the table and to be able to convey the risks and the time and the costs associated with going ahead. And so you can get them to the table and perhaps resolve cases at a better price. There are some issues, a couple things I wanted to mention. One is that it can be difficult to get other unwilling carriers to come to the table. We've seen that there are some carriers that almost as a matter of rule, no matter how bad the liability is, they don't start thinking settlement until after they see what the plaintiff's expert reports are. There's also the issue of getting the insured on board if he or she has a consent to settle provision in the insurance contract. It requires a difficult conversation, but it's certainly one that can be had. You just have to keep in mind that they have mandatory reporting and licensing and premiums that they are dealing with, and sometimes they just don't want to do it. But that doesn't mean that we can't go for it and give it a chance.
Right. And I think too, on the healthcare side, you're dealing with the financial impact. And one of the charges is, you need to know as quick as you can what the value of the case is. And as you pointed out, every case has a value, whether it's $1, whether it's $1 million, it could be anywhere in between. And as you also stated, things change over time. So as things develop, maybe the plaintiff dies in the course of the litigation. So then you have to have an administrator appointed, and those sorts of things might be bumps in the road that might prevent you from going ahead and with resolution, whatever the plan was initially. But I think risk managers need to know straight off the bat, because some of them do not have a lot of experience in litigation. They might be nurses, they might be quality folks, but maybe they're lacking that spoke of the wheel that's the litigation track or the insurance track. But to understand that, within 90 to 120 days, you need to know the facts of the case, liability, damages, settlement value, verdict value. And all of those things might be moving targets, but you have to have an initial stamp of what you're dealing with. And, sometimes you resolve cases prior to hiring a bunch of experts when for instance, if you have a res ipsa case and a retained sponge, and those cases typically go for 150,000 generally, maybe. And so if you know that information, that core information, or you get that information from counsel, it's important to go back into plan, because it's absolutely critical when you're dealing with actuaries and they're looking at your financial portfolio to project these reserve dollars. Now, some hospitals and healthcare facilities have like a third party, it's called a TPA, a third party administrator that might be doing the reserving piece of all your claims, or some hospitals have the risk manager do it themselves if they are familiar and used to reserving cases. So it might be either, but risk managers need to understand the nuts and bolts behind that and how to evaluate cases. For instance, I'd like to get your input on this. Sometimes we have staff come to us and say, I'm so scared to give my deposition. I've never given one before. Will you sit in there and essentially, support me when I'm going through this process? Sometimes the lawyer's like, no, we don't want them looking at you to affirm what they're getting ready to say. What's your recommendation on that? Do you see that a lot?
Yeah, you see it sometimes. I think that's the general thought, is that, one of the first things that I tell a witness when preparing them is, do not look at me after every single one of your answers, because it looks like I just fed you your answer. And the same thing happens with, if the risk manager is there. There might be the circumstance where it is appropriate. Every witness and every deposition is different, and you have to do what is, going to make that witness comfortable. Sometimes, while that is the conventional thought, is, to avoid having anyone other than your lawyer in there and to be concerned about them looking, off in the distance, something like that. The insinuations sometimes might not be as bad as the testimony that comes out, if they are not relaxed and if they're scared and if they give horrible testimony. So, to me, the most important thing is, what does this witness need to be comfortable? And that brings up something else I wanted to bring up too, is, there, for the past 16, 17 months, many meetings and many depositions have gone remotely. And while that does work for some of them, that doesn't work for all of them. And some witnesses, again, to make sure that they're comfortable when they're in the hot seat, they might need you in the room next to them, or it could be a doctor who's given 50 depositions and has no problem and doesn't want to waste his time coming to a conference room or yours, and just says, yeah, I can power right through this. So, to me, it's all about the most important thing, and you've got to go through a full analysis when you're deciding how to do it, is what is going to make this witness comfortable and give them the best chance of getting the best and the appropriate testimony out.
And I know, we as risk managers, we do a lot of checklists. And so for me, it's helpful in this will be helpful to our audience. If you're unsure, if you're new with litigation, make a checklist of all the things that you want. For instance, like I mentioned before, liability, damages, settlement value, verdict value. And the verdict value is, you get a lot of this information from counsel, and they're going to be partnered with you throughout the whole process if a case is in litigation or if you've hired them. Sometimes you can do the investigation on your own, but you need to look for certain things. If you review the records on your own and you see where the gaps are in care, or whether you think we met the standard of care, that's also important for the evaluation. So you're in Chicago, and Chicago, Cook County, I know you have some cases out there. Chicago, Cook County is also known as one of the judicial hellholes, which is very challenging at times to take cases through to trial and, get a defense verdict. So with cases, both non-COVID and COVID, are you experiencing any sort of movement with the courts being shut down and slowed? And also with these COVID cases, I know there hasn't been a lot of trial data, but what's your take on that? Are you having a certain position that you're taking with defending these versus the ones that are non-COVID?
Well, first, I'll start with the Cook County courts. Trials are starting to resume. I think more so in the collar counties and more so downstate. Cook County in early May opened up. They have the issue that it's a 30-story building, and there's only a handful of elevators, and they have to figure a way to get the entire jury pool, the veneer rather, to come up the elevators and sit in courtrooms while also somehow maintaining 6 feet of social distance in a packed courtroom with attorneys and judges. So, what they have been doing is there has been one trial a week since early May. That trial has to have a 4-day trial estimate. And if that case settles, they don't schedule another one. So it has really snagged, the quickness right now and just how fast these cases are proceeding. And we talked about approaching early resolution, and that's something that we can use to try to get the plaintiffs to the table. Is at this point, with the backlog of cases, I mean, Cook County has about 5 million people, and there's at least 10,000 law division personal injury suits being filed each year, and one person is getting their day in court each week. So I think that shows you the backlog, and plaintiffs not knowing when their day in court might be, might bring them to the table and get them to take something with a little less, a better price than they normally would have taken. And the second part of that, you have to remind me, Leigh, what was the second part of your question? When I get going on the trials and the wheels of justice coming to a halt around here, we tend to get a little fired up because, I think from the plaintiff's perspective and from the defense perspective, I mean, we want to get back in there. We're itching to get back to resolving these cases. It's an unfortunate circumstance, and nobody from either side of the bar wants to see it like this. But it's the unfortunate reality right now.
Well, and I think from one of our prior conversations, didn't you say that there are 0 immunity laws in Illinois at this point in time?
Yeah, currently, yes. Currently, we do not have an immunity law. There has been talk about it. There was an executive order that came out in about April of last year that provided immunity, retroactive, but it sunset sometime in the summer, July, I want to say. I know there's about 30 states or so that do have immunity laws. Illinois is not one of them. And so, I do think that we are going to start seeing a significant increase in the cases that are coming, and the strategies on how to defend those are going to certainly be playing out. But, I think we're going to approach it just as we've approached really any other case. We're going to get the record. We're going to talk with experts, whatever the appropriate expert might be, whether it's in pulmonology, emergency medicine, whatever we're dealing with. But that, that also brings us to, another point is, when it comes down to it, we're talking about how the plaintiff's attorneys, how they rely on, they want to point to the policies and procedures and the CDC guidance and medical literature. But at the end of the day, the jury is going to listen to experts on both sides, and they're going to try to come to the conclusion, based on assessments of credibility. Who do they believe? They want to know who sounds more reasonable, and they're going to come to their own conclusion. So, a lot of the experts that we get are typically very experienced, in their field. They've seen the same or the similar situation many times before. They point to their education and training and background, decide what reasonable physicians do. But here, there's little experience with a pandemic of this level. So the expert pool is going to be thin and very impeachable on both sides. So I'm very curious to see how this is going to play out once we do start seeing some more data and start seeing some of these cases being worked up further and tried.
Yeah, because, it's all about whether or not standard of care has been met, correct? And so, gathering information, that's why the role of a risk manager is so important, is we have to gather all this information for someone like yourself, for you to be able to represent us appropriately, with, as much success as possible. And sometimes we have challenges getting you the information. Sometimes it's, if you have several different technologies, when you go to print out the records, maybe they're not in the right order, or invariably there's always something that sneaks in there and it gets printed out, and you may not discover it until the plaintiff attorney says something about it, or there might be a video that we didn't know we had to produce, and then it got recorded over, and there could be spoliation allegations in relation to something like that. So it's just a myriad list of situations of what ifs, or it could happen. So I think it's important for risk managers to be able to be well-versed in the litigation piece, well-versed on the insurance piece, because of course you want to make sure that your insurance is going to cover whatever the situation might be. For instance, if you had something that was intentional, or maybe you had a gunman come on campus and start shooting folks, and the list just goes on and on and on of different scenarios, and workplace violence. We have to consider all of those things. But I think, at the end of the day, our closest allies are the lawyers that we hire to help us figure out and make recommendations. If you see that maybe we failed in a certain area, or maybe the verbiage in a policy and procedure is wrong and is too benign, or maybe too specific, which is generally because, they're going to say, well, you skipped step, 2 and 3, or, somehow we deviated from our own policy. That's common allegations that plaintiffs make. So I think, risk managers need to figure out who your partners are straight up, surround yourself with good, strong teammates. The lawyers are going to be one of those people, and you're going to have internal folks as well. You want to have a good records custodian, because you don't want that person producing records when they don't have a HIPAA authorization or they don't understand it. And oddly enough, I see this all the time, almost at least a couple times a week, where there's a record production request, maybe by subpoena from a grand jury, or subpoena, from just a lawyer's office or something like that. And the person on the other side doesn't know whether or not they can be produced. And if they produce them incorrectly, and without the proper authorizations, that could be a HIPAA violation, which could be expensive. And, everything trickles down, and it ends up being a financial exposure. So risk managers, when you think about the enterprise risk management, you have to think far and beyond, and keep asking the why. Do you have the right things in place? And that's what we're charged to do on a daily basis, is figure out not only traditional risk management, but enterprise risk management. And so, it's hard to do both. So you need to figure out, how you're going to structure that, how you're going to accomplish that, and know the goals and business strategies of your organization so you can help limit and mitigate loss exposure. But that being said, I mean, one of my favorite things is, because I think we don't do a good job of this, is communicating back to our organization, to our people, because I think that's when the real learning occurs, is when you can tell somebody, as a result of X, this is what happened and this is how much it costs the organization, is lessons learned. And oftentimes, we don't have enough time to do what we're charged to do. So that kind of falls by the wayside. Yeah, we handled it, we capped our exposure and we moved on. But what about the nuggets of learning and pushing that out to frontline staff? Because I've seen firsthand, I mean, people come back and say, I don't know what happened. I didn't know the significance of my error and how that impacted, the organization or the department or the patient. So do you have any favorite lessons learned nuggets for risk managers as they move through in their practice that you feel like, we need to hear from your side of the fence?
Well, the first thing you brought up, I mean, that's an interesting point. I think risk managers should be paying attention, to these suits, and not just when they're filed and dumping it off to the lawyer. You should be thinking about, do our policies and procedures need to be adjusted for the next time? That's, we do actually get some benefit of hindsight. It's not for the case that's going forward. We try to, as the lawyers try to show, well, of course, there's retrospect bias and hindsight bias. It's not for making admissions that, yeah, we should have done it this way. But this should be, when something happens, and the lawyers end up fighting a very costly battle over peer review documents, as an example, then, for the next case, you should be prepared to make sure that the policies have been adjusted, that the appropriate person, for example, is starting the peer review process. So, so you can point to the fact, okay, this is Illinois law. We started the committee on this date, then we did everything after that. So all of this is protected by the peer review privilege. So, it's learning lessons and making sure that you're continuing to, to monitor these cases, that you're talking with the defense counsel. I think that's the best way to handle it. Keep in communication and keep communicating those changes in policies, and make sure that the various hospital personnel are getting those changes in policies too, and that they understand, exactly, what's different, what's new. You need to follow the policy to be able to do that.
Right. And I think we as risk managers, we guide and direct. We can't possibly do all these things ourselves, but we need to have the education and the knowledge to be able to guide others, right? And so, I was at one institution and quickly realized they had over 6,000 policies and procedures. And so when I started looking through them, no one knew how to find them. They were not updated. Some need to be retired. So what we ended up doing was having a policy party where the CEO joined us. And, we had the conversation. The employees can't possibly know all of these. And, whether or not they were based on best practice and updating all of those, it took a while, but they were all sifted through and cleaned up. But I think, that's only one small example of some of the big projects that we have to be, either leading, guiding, participating in. So it's important to have the right people in the right roles with the right skill set to be able to drive it to the next level. And I can't stress that enough. Just because maybe you might not have all the knowledge in litigation, but guess what? If you surround yourself with the right people, everyone will shore up what they need to shore up, and you can operate as a good, strong team. Oftentimes what I see is the wrong people are in the wrong spot because the position need to be filled, and then therefore things are falling through the cracks. Sometimes this happens in medical records. Maybe somebody went out on medical leave and they needed somebody to step up and fill the seat, and they don't have all the knowledge and background that they need to have to produce records in the right way and not create exposure for the institution. So that would be my recommendation too, is, those are lessons learned for the organization that are just huge nuggets of learning. And I don't care how old you are, how long you've been in the industry, you will always learn something. You're never too old to learn. And when you get to the point where you don't think you're learning anything, you might need to consider exiting or doing something different, because I think, we have to be willing to lead. We have to be willing to follow. And sometimes they're at the same time and sometimes they're not. And so I think that's what makes a good risk manager. It's not it's the team, it's us. So my motto has always been, we rise as a team, we fall as a team. So it's not just one individual pointing blame at one person or the other. We're going to do it as a team. And so I always try to do a quick analysis and study on, I have all my staff do swim lanes to see where they're strong, where they're weak, what needs to be shored up. Can we cross train? Because I think that's also important. And also for risk managers to do succession planning, because when you don't, maybe you're caught in a pandemic or an epidemic and you haven't trained anybody. That's a real weakness that organizations need to think about, is you need to train others to be able to step into your role in case you don't come back one day, or maybe you get sick with COVID and you're unable to come back permanently. So I've had, multiple, I know everybody has known somebody that's, gotten sick with COVID, and, you're fine one day and the next day, things are different. So I think that's a huge lesson learned for succession planning and skill set evaluation. But I think that, regardless, the legal team is critical to any organization, and there's all different aspects of the legal team. We really didn't touch much on the workers' compensation side of things, but the risk manager, depending on the size and scope of the institution, may be over workers' comp or may not. If you're big enough, you're going to have all different sorts of specialties that are run in different segments or different spokes of the wheel. If you're small, you may be doing it all. So that's also important. But I'm always thankful for my lawyers because they're good. We always have, good lawyers on our panel list. And that's another thing that risk managers, if you have not been able to participate in evaluating, you usually have a panel list of lawyers that you can pick from that have different specialties that can help, at a moment's notice, you need to make that phone call, because in the hospital setting, you cannot say, oh, I'll call you on Monday. Things happen real time. People are at your door. You have to be quick on your feet and you have to respond to the chaos and the needs of the institution immediately. So it's different than, being shielded to say, we'll touch base with you next week. Normally that doesn't happen. So it's imperative that you have good people at your fingertips at all different hours of the day, so you can actually handle the crises, as they happen. So I just want to thank you, Scott, for being one of those people. I know I've had to reach out a couple times.
And we are always happy to at all hours of the day, we are ready to step in and help out in any way that we can.
Thank you.
Hey, can I interject a question? Do
Sure.
plaintiffs take their cases into the court of public opinion, and what do risk managers need to know about when that happens? That was part 1. Check back here for part 2 after August 8th, 2021. As you heard from Leanne and Scott, documenting your case is very important. Our sponsor, SafeQual, has excellent software to help you do just that. For more information, go to their website at www.safequal.net. On the top there, click Key Functions, then scroll down to the Claims Management section of their Key Function page for more information.